I'm Fred, I don't mind.
Mine's Ahmed, I have a preference.
And we just introduce the team. So Oxford C, we have
Nat speaking first.
And Tommy EUDC.
and Sheffield.
Adam EUDC.
Matt EUDC.
Durham
Josh,
and Oxford.
Case University.
Crash, Sheffield A.
Okay, so the motion before the House is this House believes that Supreme and Constitutional Courts should not have the power to strike down legislation. So without any further ado, it's my pleasure to call upon the Prime Minister to speak to the motion by his name.
opening opposition think that democracy is when you get the will of the majority and lots of people have their say through a loud header all the time. They think that a democracy is a situation in which the majority wants something that should always go through and that's something we benefit from. If that's what they think that democracy is, woefully poor, right? 3 things in this speech about why, and it's quite simple, right? Why we should have checks and balances on democracy and on the will of the majority, and why, if 2/3 of the population want to do something, that is sometimes not okay. Firstly, why these checks and balances exist, and this is a good one. Secondly, why constitutions stimulate debate around particular policies and can be changed, why we think that change is better on our side of the House. And thirdly, how they make positive changes that can't happen due to perverse political incentives. First of all, some points of response. Into his first point about how they're not independent, this is completely uncomparative, right? Clearly they are more able to be independent from politics in as much as they get live terms. Of course it is the case that they will initially say what stance they're on a certain issue, but they are more likely than the Congresses or Senates or particular parliaments to put through these changes, right? And this is like clearly something that's just trivially true. Secondly, in terms of them being accountable to populations, no, that's not their point. They're accountable to constitutions and legal codes instead, right? Which is a difference. So yeah, we agree they're not accountable to populations. And thirdly, they're not reflective of populations, like transfers out the same old analysis. They're all white men we've heard in every debate. Factually untrue. The Supreme Court is usually more representative on the comparative of the ethnic population than the Congress or the Senate are, right? This is because they recognise there's an incentive to give these institutions legitimacy by making it, right? You have to be comparative in debates like this, right? Secondly, he talked about democratic representation. Yes, they're not democratically representative, that's our case. Thirdly, he talked about how direct democracy is better, going to get into that in a minute. And finally, at 7 minutes, he talked about how we get better institutions, so not going to bother with that. Firstly, right, why we have checks and balances in systems, and this is a good thing. Parliaments are a good check and balance on the executive in as much as you get democratic debate and ensure that they're not doing something which goes above and beyond their power. Supreme Courts are particularly good because on the comparative, they are less political and less responsive to the demands of particular populations. Why is that good? We think there are 3 things that are wrong with politics on which are perverse incentives which need to be checked and balanced. You can hear that a lot in this debate, right? Firstly, why supermajorities mean that large popular opinions at one particular time can mean that minorities are enormously damaged, right? I'll impact this more in a minute, but notice that when you have very, very small minorities, right? So when HIV/AIDS was an enormous issue in the 1980s, polls repeatedly suggest that they favoured putting these people in an area where they would be quarantined in order to not damage the rest of the population. This was an enormously popular policy because it was a tiny majority and clearly had an enormous utilitarian benefit. Don't think that's okay. Secondly, short-termism in elections. In order to win elections, it's an incentive of politicians to play up these fears in order to get their votes. Therefore, what you get is a situation where these bad popular opinions are exacerbated, right? This is clearly a poor issue. Notice in the issue of like Brown versus the Board of Education, lots of very, very good, good changes the Supreme Court have made. There was no way politicians could have come out and made such an unpopular call because they would have been enormously damaged by their constituencies. Supreme Courts are able to do this because they're not representative. Thirdly, like sometimes they are just ill-informed, right? It is true on the comparative that Supreme Court justices, when they are put in place, have to have a strong background in legal representation, right? There are always debates about how strong this background is, but certainly have experience in this. Politicians can just be blokes, right? They can just be, women, sorry, gender term. They can just be people that have just like come off the street and decided they want to run for these elections and are more likely to make just crappy decisions, right? They're more likely to ignore procedure because they think it is irrelevant, more likely to adopt policies which would be damaging in the long term but haven't been thought through, right? 3 enormous problems which we think are solved by Supreme Courts. Why? In terms of supermajorities, on our side these are challenged, right? You have a Supreme Court which says, look, we recognise that the vast majority of people think this is popular, however we don't think it should be put through because it is inconsistent with the founding concepts and beliefs of our state, right? A bit more on why that's particularly important in a minute. On our side, you get discussion. If it is true that the supermajority should make the change, and it is a bad part of the Constitution, there is a discussion about whether a constitutional amendment should be passed, right? This is possible in our world. We think because that discussion says, hang on a minute, we're not just talking about this policy, but the founding principles of our state, that is a better discussion and one which gives that particular policy, which may damage minorities, the gravity and the weight it deserves. On our side, on their side, you get absolutely no changes in policy if something is unpopular, but clearly going to be good for a minority because politicians are unable to ignore their constituencies, because if they do, they get voted out. On our side, you get these unpopular changes. And finally, right, this is trivially true, but like not important in debate land, but obviously important in the real world, you don't get crappy policy. Like if someone puts in a particular policy, so the Ugandan government just try and get through a policy on anti-homosexuality, which is obviously principally wrong, but just try and rush it through and don't get the appropriate quorum, right? They do this because they have incentives not to recognise procedure and to do things in a poor fashion. The Constitutional Court can say, no, we're not going to let you get away with that, regardless of how popular it might be. You didn't follow the correct procedures that your forefathers and the population would probably support if they understood them, right? Now, go.
In many countries, particularly in the developing world, constitutions do not provide protection for minorities and support a majority group. What our model does is it provides greater protection than the constitution of your model.
Borderline racist and untrue, right? The people in the developing world don't have any opinion for human rights, right? Why? And this is my second point, so let's go on to it. Constitutions stimulate debate, right? What we think is that because these constitutions are the founding documents of these nations, right? The process by which they are formed, particularly in developing nations where there are new governments, particularly in Latin America, if you look at the pink tide where they came in and rewrote many of their constitutions because they thought it was popular to have a new foundation for their states, often after there were serious dictators there. Because these are processes that you say, what is it this nation stands for? What do we believe in? They are far more likely to contain elements, positive elements of law regarding human rights and the protection of minorities. Notice the Bolivian constitution, when it was written, regardless of the fact it was in the context of an incredibly racially divided state, recognised Bolivia as the first multicultural state, a multi-ethnic state in the world. This was something they thought, moving on, that was important to them, right? Notice that human rights have an enormous amount of buy-in across the world. Like Matt's got the stats on this, but right, in terms of recognition of human rights as being important, there's something which has an enormous amount of buy-in. Actually, in the developing world, they don't like human rights. It's untrue, right? So why is this particularly important that these constitutions are more likely to include elements about human rights and defending minorities? Firstly, because when something is struck down saying, look, there is an unintended consequence of this policy, which means it's going to harm this minority, you haven't thought this through, that stimulates a debate that says, hang on a minute, we originally thought this was the right idea, but actually now we've been told that this goes against the founding principles which have an emotive buy-in from populations. This is not something we want to do. If it is something, when they say, hang on a minute, you're going to have to change and amend your constitution in order to put this policy through and change your founding principles, and if that policy is so racist or whatever that occurs, notice that's true on both sides. At the very least on our side you get more of a discussion and a challenge to that, right? Racist exist in both worlds, we have more of a challenge to them, right? So their referendum thing is nonsensical, right? Notice when I do my POA, it goes, that's why we chose 66%, not 51, got you there. No, actually they have the exact same problem, right? In as much as if 51% of people believe something and then 66% believe it and it harms 1% of the population, on our side that is less likely to happen, right? And we do not want that to happen. On their side, it does happen, and not only does it happen, then you have a constitution which now enshrines that particular racist law and makes it harder to challenge in future. I've criticised Matt for it, but my third point I've gone to in 7 minutes. So let's say Matt's going to talk about how you get positive changes through Supreme Courts instead. I mean, it's just a really terrible idea, and I urge you to oppose.
Ladies and gentlemen, I might be willing to agree with side opposition if I thought that constitutions genuinely represented the moral truth of the matter, that they could always be applied with the full support of all of the people, and that a council of wise men from a particular ethnic group or a particular class group could always accurately and positively tell us what was contained within this moral truth. The constitutions were written by certain framers in a certain time from certain groups of particular interests. It doesn't protect everybody, because judges come from a certain generation, a certain group with certain interests. It doesn't protect everybody. And for these reasons, and finally because we don't think that people are always going to just buy into whatever it is that the Constitutional Court rules, for these reasons I'm very proud to be on side government. What am I going to talk about today? First, I'm going to talk about why there's no particular reason to think that constitutions are particularly good or better at protecting groups than the people as a whole. And second, why it's particularly important in newly democratic countries where you need to have the population recognise that this is that democracy is a good thing, that it's something which is reflecting their views and is simply not an overhang of the old oppressive system, and to get them to buy into it. No thank you. Before I move on to that, I'm going to respond to some of the things we heard. So One idea that we got from opposition was that on their side they get more debate because people say, oh, this was unconstitutional, that's weird, maybe we'll talk about it. Actually, we get more debate on our side because on their side, the debate you get between groups who are vying over whether you should have, say, abortion rights don't need to talk to each other. They don't even need to advance the real arguments why they think that rights for abortion are a good thing. They advance legalistic arguments, so they don't even properly represent what their views are, and they don't have to talk to each other at all. On our side, when you then get that referendum, it means they actually have to engage one another. They actually have to say, here's why we think it's really important for people to have abortion rights. No, thank you. And so for we get a much richer debate, one where you actually get dialogue and where you get the actual issues being discussed. So this is good for a couple of reasons. One, for all the reasons the opposition told us that it's a good thing to have debate. But second, also it reduces tensions between sides when you actually understand the problems that a certain minority group are facing. We think that this protects rights more in the long run, because if some people can say, actually, yeah, maybe it is important to have abortion in certain cases, then it means that you don't have the situation we have at the moment. We have a polarised judiciary, a polarised population, where they're constantly trying to get like certain measures passed which bypass the constitution in lots of clever and nasty ways. So like, for example, in the southern states, we have horrible invasive procedures to try and convince women not to have abortions. They say, yeah, it's just about constitutional, we're allowed to do that. Instead, if you get this understanding, it means that people don't try and bypass the constitution, and you get a much better protection of rights in the long run. So like that's like most of my substantive rebuttal. Yeah, I'll take Crash.
But the point about Roe v. Wade was that there were some states in which you literally could not get an abortion at all before it was passed. So doesn't it?
So interestingly, by the time that Roe v. Wade came along, abortion rights were already overwhelmingly popular. The Constitutional Court came behind the population of the United States. Only about half a dozen states still had laws against abortion at the time, and there were already proposals coming in order to change those rules in those states. The Constitutional Court reacted very late. They refused to listen to any abortion cases for about 20 years before it because they thought it was too controversial. This is a case where the people are more progressive, no thank you, than the court. So then, moving on to like my first point, there's no reason to think that constitutions are particularly good. This is for three like general reasons. Framers have no special access to moral truth because they were written at a particular time, and judges who interpreted it from a particular background. So the first point here is that, like, generally speaking, like, as a group, I don't think we believe in, like, a council of wise men who can work out exactly what perfectly, like, the correct rights of a certain group is or is not. This skepticism is why generally we're liberal, why we let people lead their own lives, because we say we don't think we know what's best morally for you. It's also why we're generally democratic. We don't have this council of wise men, as you do in some countries, saying, these are the true moral principles we should all be aiming for. We'll let our civil service, no thank you, maybe, like, work out the means to them, but we don't think people are only good at working it out. Given we allow democracy in every other area, it's not clear why here, just because of a historical accident, that some countries really did believe in a council of wise men when they set up, that we still let this idea of council of wise men continue. But not only does this apply on the kind of abstract level, it applies very specifically. Framers often represent a certain class and certain interests. In the US, in Australia, that means like middle-class white men. When it comes to like newly developing countries, it's usually like the victor ethnicity in whichever country we're talking about. So for example, like with the Constitutional Court in Egypt, for example. No, thank you. So this means they also represent a particular generation. It's not clear that what the Council of Wise Men thought in the 18th century is particularly true for morality or protecting minorities today. People, no thank you, are more likely to represent all interests than the framers who represent a particular interest at a particular time. And so, as we was raised in a POI, in many countries, like the Constitution simply doesn't protect certain minorities. We were told we were just racist when we said this. No, we have specific examples. In Papua New Guinea, they said the minorities in the east of the country have no specific protection under the Constitution. Similarly, when we're talking about like Sri Lanka, the Constitutional Court ruled saying that Tamils have no special protection under the Constitution. There is no reason to recognise differential rights for them. These constitutions in more newly democratised countries more specifically ignore certain ethnicities because the court is overwhelmingly made up of the dominant ethnicity. Even though the minorities we accept are going to be shut out in some way, they're still a minority. At least they get some voice in the decision, unlike on their side, where they're just not represented in the courts and get absolutely no voice in the decision. So like, and also on this idea that maybe like courts are more progressive than the people. So this is just factually untrue. Like, the US Constitution includes the 3/5 compromise, for example, which says that black people count specifically for 3/5 the worth of a white person. This was obviously nonsense. And the people even started rejecting it only 30 years after the Constitution was passed. It takes another 80 years for it actually to go because it's so difficult to change the Constitution. When the Supreme Court struck down New Deal policies, it kept slavery constitutional even though the people were against it. It's just not clear empirically that courts are much more likely to protect rights rights than others. And finally, in newly democratic countries, when you have people who are saying, right, we need to buy into this idea of democracy, this is what we've been fighting for, that our views get represented. Instead, they passed an elected law, elected whatever, through their representatives, and it's struck down by the court. It means that, one, they don't think the democracy is actually working, it's not representing what they say. Two, it just looks like dictatorship again, quite clearly. Three, the courts are usually filled with people associated with the old regime, because they're the people who are most educated, who understand the system, they naturally get elected. Like, that's what happens in Egypt. The Constitutional Court is basically all the same people of the old cronies in Mubarak. And finally, it means the courts are much more easy to corrupt than the people, because you can bribe them, you can intimidate a court of 9 people. It's much harder to bribe, much harder to intimidate, an entire population, which means that the people are much more likely to make better decisions. And if the court then strikes it down, it means they're not going to buy into the regime, and they're not going to support it, and may even return back to the old conflicts they went to when they said, we wanted to fight for democracy, we don't have it, we want to fight for it again. Because we want to protect democracies in newly democratic countries, because we want to protect minority rights, we're very proud to propose. Thank you.
Thank you, Madam Speaker. We hold these truths to be self-evident, that all men are created equal. It is good that that was written in the American Constitution. That is not the tyranny of old white men, but something which helped and aided the civil rights movement throughout the 20th century. Law is not separate from morality. Law decides moral questions. We think, therefore, that there can be morally illegitimate laws, and we think that on our side, we stop those going through. Laws do not gain all of their legitimacy from direct democracy, from the tyranny of the majority. Right, 3 points today. First of all, why this is democratic. Secondly, why this protects popular principles. Thirdly, political changes. For that, however, one big bit of rebuttal. So we get this idea that there is no moral truth. We say, well, maybe, but that's not what we claimed, right? What we said was that constitutions were substantially better than the tyranny of the majority, who are open to, for example, large corporate interests able to swing referenda or emotive issues. Look, for example, at anti-terror legislation after 9/11. Vast numbers of things went terribly wrong when George Bush and Tony Blair were able to stand up and go, look, but we need to do this, right? Huge principles were pushed aside, and it was only because of Supreme Courts that was kept in check. It was only because of the House, the Law Lords and the House of Lords that we managed to maintain detention without trial down to below 30 days. These are the things that we are proud of within Supreme Courts. We get no response to all of Adam's stuff, right, about when people do want to do really bad things. Like when 80% of people in the 1980s wanted to quarantine HIV/AIDS sufferers in rural bits of Scotland. We think that's a terrible thing, and we are glad that they aren't allowed to do it. Where is this idea coming from, that moral truth can't come from individuals, but it was always just what the majority believed? We say there are loads and loads of examples where that is simply not the case. Right there. And finally, he says, there are constitutions in Sri Lanka which aren't as good as they could be. We are quite willing to say that constitutions in Sri Lanka should be better. We say that it's also good at the point at which you actually have those principles enshrined in law saying all people are created equal. You then actually provide a narrative for embattled minorities to claim we have a constitutional right to something. You do half the work for them. They are suddenly able to say, at the point at which you consider me human, I deserve these rights. But half of the argument is done for them by the Constitution. It's much, much better for a minority to have that constitutional claim than have none at all. First point, why this is democratic? So we keep getting this idea out of opening government that democracy is just simply as what we can poll. Well, as long as 80% of people want something, or 66% of people want something, then brilliant, it's moral. We say no, because democracy is much, much more than just voting. If you have no access to liberty, if you have no access to equality, what is the point in that vote in the first place? If you can't actually get to the polling station, or you have to put your hand up in front of someone who terrifies you to declare your vote, that is no real vote at all. If you can't actually declare the things that you want to declare in political discourse, there is no actual self-rule there at all, right? Democracy is more than a vote, but rather the principles of self-rule which require equal access to that self-rule. When you shut people down through anti-terror legislation and say, no, you cannot say this, or no, you cannot preach these things, that means that you have much less power, right? Democracy, therefore, isn't just voting. At the point at which voting starts to infringe upon those principles of democracy, the reason we have voting in the first place, we say that voting actually starts to become illegitimate. For example, if we were to elect a dictator, who then removed all of democracy, we would say that that vote was probably an illegitimate use of democracy, given it would be offending the principle it's trying to protect in the first place. We say that the principles of democracy, therefore, are so much more important than simply the arbitrary will of the people. Right then, why this protects popular principles? Because Adam promised you facts, and here they are. So, the UN Declaration on Human Rights was presented to 51 member states of the UN. 43 of those ratified it. South Africa didn't because they were being racist. Saudi Arabia didn't because they didn't want people to have freedom of religion. The USSR, the Belarusian SSR, the Ukrainian SSR, Yugoslavia and Czechoslovakia didn't ratify it because there weren't enough rights on economic and social rights. The international covenants have the highest adoption of anything put forward by the UN. On average, they get 172 signatories. That's over 88%. There is no principle more loved than the idea of human rights anywhere. You will not find a government that says, we do not like human rights. It's very hard to find one who will not make that proclamation. Constitutions don't tend to say, we will always oppress this particular group. Constitutions don't tend to say, we will always be really, really bad people. One, because people don't actually genuinely believe they are immoral, they usually believe they're on the right side of the argument, but secondly also people don't want to have the international condemnation they know that would get. This brings me to my point that I mentioned, point of rebuttal, right? Because as soon as you give that constitutional key to someone and say, look, we have it written in the founding documents of this entire country, I'll take you in a moment, you allow them a much, much easier path to genuine equality. Closing.
Isn't it odd that you use the UN Declaration as your example, when that declaration gives absolutely no strike down powers to any court on the planet?
Yeah, but also it's good to have it in general, right? I'd probably be happy with more courts able to support the UN Declaration, but it's very good in terms of a prescriptive thing, which is able to also encourage people through applying political pressure. The point wasn't that the UN Declaration has strike down power. The point was that people like human rights. It's a lie when opening governments say people don't like human rights. You're being colonialist. Just not true. Okay, no, thank you. Right then, so what do we say, right? Is that, however, despite these principles, people can be terrible. People can be shitty. People can try and avoid the principle or don't realise that they're offending the principles which they thought were so incredibly important. When you have these emotive situations, when you have anti-terror legislation, people need to be told that, hang on, this might seem sensible now, but look at the principles which you proclaimed were so important to you. This is what Supreme Courts can do. Right then, political changes. How do we make positive changes away from political incentives? Because notice, democracies aren't perfect arbitration machines. They are not actually always even the will of the people, right? Referenda can be thrown, for example, by huge corporate interests. Look at Proposition 8 in California. Vast amounts of money is able to be thrown into campaigns and then to push people away. This is why, actually, we have laws on funding, right? Because that actually protects the basic principles of democracy that we want to protect, which ties into that first point about why democracy is more than simply just voting. What we do here is we actually allow people to make decisions that democracy wouldn't allow them to do. Brown v. Board of Education was never going to be pushed through by a Missouri governor who relied on an incredibly large racist majority to keep him in power. It was never going to be pushed through by governors who were funded by explicitly racist and segregationist organisations because he was never going to go back in power. It was the bravery of judges to say, no, this is immoral, no, this is in our constitution that was so incredibly important. We protect a genuine view of democracy, Madam Speaker, not offensive tyrannical majorities. We protect minorities. They want to sacrifice them to the altar of majoritarianism. Very, very proud to oppose.
Madam Speaker, we find it odd that the other side of this House refused to admit that when the Supreme Court does not have strike-down power, that it has any power at all. We on our side of the House think that the power on our side of the House is more constructive and produces better outcomes, and we're going to prove to you why accountability and results lie on our side of the House. I want to talk about two things today. First of all, how the law develops / how do we control government excess? And second of all, how the behaviour of constitutional courts when they have strike-down powers is incredibly damaging to how we develop as nations. Okay, first of all, extraneous rebuttal that does not fit in. So, what we like to say are no protections for minorities, okay? It is true to say that some constitutions just do not have protection for those minorities, okay? If the protection does not exist, that court cannot invent that, okay? I'm going to come on to why it is wrong to assume the law is necessarily moral, okay? Courts are not just free, Madam Speaker, to decide as they will on moral decisions. They have to decide in accordance with law, okay? Without specific provisions, it is not clear why that necessarily protects minorities better on their side of the House. And then they go, constitutions are good, right, because they provide a grounding as to the ethos of that state, okay? No, Madam Speaker. This ignores the nuance of different types of constitution, okay? If we were talking about more detailed constitutions, like the German constitution, then perhaps, okay? But the problem there is that the German Constitutional Court takes an extremely restrictive approach and slows the political process in Germany. For example, that's the reason why the German Constitutional Court has not allowed transgender rights to become a thing in Germany, because it is not necessarily compatible with some provisions like Article 2 of their constitution. No, okay? And we think the other types of constitutions, some are very vague and idealistic, like the South African constitution, and the problem there, as I'll come on to my substantive, is the courts often steal that vagueness and expand their power to again slow the political process when progressive ideas want to trickle through. Right, now their bigger claim. They say law is moral and making legal decisions is a necessarily moral thing. It is just categorically false. Why is that? Okay, law, Madam Speaker, reflects societal norm. This is like jurisprudence stuff, right? It's pretty boring, but it's important, right? Okay, constitutions reflect antiquated norms. Okay, they don't reflect necessarily good norms. Okay, it is not good enough for Wilmore to say, look at this like nice provision of the US Constitution, and for that to therefore mean that all legal decisions are moral decisions. Okay, I can also counter-assert that the Canadian Constitution is really vague and actually like slows progress, or rather like the US Supreme Court during slavery were very against granting that kind of freedom because it was not a provision that existed in their constitution. No, okay, Madam Speaker, they failed to prove that there's a necessary link between constitutions and morality, and without that link, their idea that there's necessarily a good check on immoral decisions that hurt other people is just false, okay? And then they go UN Declaration, right? And Wilmore missed the point of the POI. It's funny that he chooses a document that grants no court any strike-down power at all. And then he goes, but it's proof people like human rights. It's like, yes, I live in the United Kingdom. We like human rights too, but as I go on to my speech, we think the soft review mechanisms are a much better way to achieve political change, okay? He ignores the fact that documents like the UN Declaration are part of the political process. They are one item in a matrix of factors that help to contribute to aggregating preferences to make better decisions. We think it is funny that he uses that example. No, thank you. Let's go into substantive now. How the law develops and how we have better control of government excess on our side of the House, okay? They say, and they kind of assert this, that, constitutions are a check on the tyranny of the majority, okay? First of all, see my rebuttal about why law is not necessarily moral, but why that is probably not true, okay? Even if that is true, we're going to prove to you why that is better on our side of the House. No, okay? Or assume that without strike-down powers, the Supreme Courts are powerless to do anything to influence the political process. No, okay? We focus on, without strike-down powers, how courts have better political pressure and how soft review mechanisms are more effective at defending rights of individuals. No, thank you, okay? Government excess, Madam Speaker, they ignore this, often comes not from passing really awful legislation. It comes from expanding their powers beyond which legislation already grants them, okay? People get really riled up if you pass a piece of legislation saying, we take the citizenship off all Jews in our country, but they get less angry and there's less chance of political backlash if a government harnesses a pre-existing piece of legislation to say, we're going to lock up all of this minority, as happened in the United Kingdom with the Belmarsh case. No, thank you, okay? As I've said, like in the UK with the Belmarsh case, judicial review is a much more effective mechanism to control that excess, okay? First of all, we think it stops the bulk of excess, because the bulk of government excess happens through expanding your powers beyond which pre-existing legislation already grants. No, thank you. But even if it is legislation that's the problem, why are soft review mechanisms better, okay? For example, the ECHR, okay? In the United Kingdom, the UK Supreme Court has the power to declare the legislation incompatible, but not strike down with that document, okay? Why is this good? Okay, so, for example, in the case of Goodwin, like, the UK Supreme Court was able to declare legislation in the United Kingdom that denied transgender people recognition rights to be incompatible with the ECHR, okay? That was important because it pointed out a lacuna in the existing law, okay? It also created a large amount of political pressure that elicited a change in that legislation from the British government, okay? Why is that more powerful than a strike down, okay? First of all, a court can be seen as an oversight mechanism, not a meddling mechanism, okay? If a court is seen to meddle, i.e. like stopping stuff happening that people think should generally happen, okay? The respect and legitimacy of that court is undermined, and the views of that court when it strikes down legislation are ones that are less respected. No, thank you, okay? We think also that that soft review mechanism does enough to strikes the correct balance between respecting the democratic process and the aggregation of those ideas and still providing a slow check. So, for example, you can declare a piece of legislation incompatible, and that's saying to the public, do you really want your government to do this? And it is acting like a sieve as opposed to a wall. I'll take opening.
The US Constitution was formed in a state that was deeply racist and homophobic, yet has been consistently used to defend the rights of minorities since then.
Right.
How does this square
Categorically not true, okay? Decisions like Hobby Lobby and Citizens United, which have been used to like expand the powers of companies to include that of religious rights so that they can oppress minorities and oppress groups like women who want access to contraception, is my example of how I can counter-assert that they don't defend minorities. I've explained to you why law is not necessarily moral. Finally, let's talk about the behaviour of these courts, okay? They're often populated by legal elites, okay? Legal elites prefer a stricter interpretation of the law, okay? They're often usually conservative due to the background and education they had, okay? The consequence of this is they are often restrictive to change. They are happy to often strike down legislation because they prefer to err on the side of caution. Why is that a problem, Madam Speaker? First of all, we think that it forces legislatures to act defensively. Why is that a problem? Okay, legislatures are reluctant, and governments are reluctant to propose progressive and radical pieces of legislation for the fear that that legislation will be struck down. Okay, governments often prefer to save face and to not be seen as incompetent by passing legislation that is struck down by a Supreme Court. Okay, that is why Obama was very, very reluctant to even introduce the Affordable Health Care Act in the first place, because of a fear that as the grandstand piece of legislation of his premiership, that it will be struck down. Okay, there is also a second harm here, Madam Speaker. The point is, in the case of vague constitutions, of which many, many countries in the world have, for example, South Africa, Supreme Courts often use that vagueness, they harness it, and use it to just expand their power, okay? That happened in the example of Citizens United and Hobby Lobby, where they used a freedom of speech right to give companies rights that they shouldn't have had, okay? The problem with that, right, is that they use this broad base to slow the political process even more than is necessary, right? They use that expanded power to say no to progressive legislation, no to change. Madam Speaker, on our side of the House, courts are more legitimate and protect the rights of minorities more effective. We're very, very happy to propose.
Sorry, just stopping it from auto-locking. Ladies and gentlemen, opening opposition have told you in this debate why Supreme and Constitutional Courts often and most usually make decisions that are better and protect minorities. What we're going to tell you from closing opposition is that not only are they usually beneficial, but even in the cases where they're not, why overall we think that constitutional courts are a legitimate aspect of democracy and essential for the perpetuation of democratic functioning. I'm going to talk to you about why it's essential for democracy in terms of judging administrations by incontrovertible principles, preventing tyranny of the majority, and preventing sliding to authoritarianism. Firstly, a lot of rebuttal. Just like clear up this model, right? Because they seem to assume the model they actually propped was that you need 2/3 of people to declare it unconstitutional. So really, all you need is 34% of people to say they're totally fine with an oppressive law. That's fundamentally something that we think is particularly democratic. That's what you said in clarification, right? We think that's incredibly problematic in other reasons, right? Because they've said that they assume here that the public are qualified to say what is constitutional and what is not. It may be qualified to say what they want or what they don't want, but saying whether or not something is constitutional is fundamentally different, right? So how people in the United States interpret the right to bear arms depends fundamentally on their political opinions, not upon the constitutionality of that, right? So some people think it includes the right to carry AK-47s, others don't, based on literally nothing to do with legal precedent, right? Also, they seem to assume that populations are generally inclined towards being nice to minorities. Fundamentally false, right? Populations have consistently proven themselves willing to override the rights of minorities for the case of expediency and popularity. Note, the majority of people in the UK want to repeal human rights law, right? They want to live in a state with no human rights legislation because they specifically want to oppress minorities. No, thank you. Moreover, let's look at the characterisation that they've given of constitutional courts. Two things here, developed democracies and developing democracies. Like, firstly, I think it's pretty sneaky to put in developing democracies here, right? If they say, like, they're stuffed with political appointees by, like, the dictator or the authoritarian leader, I mean, probably true. That country's got bigger problems, right? Such as, like, a lack of democracy. So, therefore, we should probably think, like, well, where does this function best? Oh, in developed democracies, right? If you're saying that, like, in the case of developing democracies, it's true that they're not a sufficient check on the government because they're, like, stuffed with their appointees, but moreover, they don't make anything worse because the situation was really bad anyway. So let's look at developed democracies. They said that, like, first, like, it's old white men. No, the Supreme Court has a third women. This is far more representative than either Congress or the Senate. They also said, well, they're just political. Firstly, like, I mean, there's a check and balance on this, really, in terms of how they're appointed so that they can't be overly political. Moreover, they have an incentive not to be, insofar as they want to maintain legitimacy. In cases where they have been too political, such as blocking FDR's economic policy, Congress actually threatened to add loads of judges, meaning that they backed down from that, acknowledging that they'd overreached. This is what checks and balance in democracy looks like. It's why we constrain the behaviour of others. We think that they're, like, also on the basis, right? If you're saying that they're political, you have to look at the comparative. They're certainly less political than either the population or the government, simply because they're abiding by these incontrovertible principles. They also said, like, we had this from closing, that, like, the Constitution reflects ancient laws and stops progress. What they've said here, though, assumes that progress is linear. And this is major problematic. There's actually lots of points in a country's development when progress regresses rapidly, or where there are certain instances where actually they decide human rights law may not be a good thing, right? So it may be, if it's true that it stops progress, or it makes progress slower because you have to go through different sets of amendments. But that is far less of a concern than stopping rapid regression, right? Because the harms that accrue are much greater on that side. They then also said that it's sufficient to declare it incompatible. Note, no. That's undemocratic because that depends upon the authority of the court over the executive remaining constant over time. If you have a more right-wing or more authoritarian government come in, then the likelihood of that administration abiding by the court's rulings differs, right? This means that fundamentally some administrations are subject to to what the court says more than others. Moreover, this gives incentives for courts in the time of more authoritarian administrations to actually tread very lightly. Because if you know that you're going to simply be overruled every time that you try and say something, this actually makes you very worried about the fear of becoming irrelevant. This means that there's even less chance of authoritarian governments being subject to the rule of the court in the same way that liberally minded administrations are. It's fundamentally like a differential check on different administrations. That's unfair and undemocratic. Yes?
It's more likely to protect the rights of Tamils. A Supreme Court comprised exclusively of elite singlees, or a population which needs a 2/3 majority in order to pass laws.
Okay, so we think in the situation of developing democracies, they have bigger problems like wars, and moreover, there's no situation that you've given me why the rest of the Tamil population would be willing to pick the right to the Tamil Tigers, given they've been told they're terrorists all the time and that they're willing to launch a war on them, right? Given that the vast majority of the Tamil population think it was totally fine that they annihilated the Tamil Tigers in what was thought of as an ethnic cleansing, we think they're probably not going to be too fast. Right, finally, why is democratically legitimate? It is simply false to say that legislation emerging from administration is automatically a legitimate interpretation of the will of the people, because the administration has given enormous freedom to act once in power. You know, the Labour government and anti-terrorism laws. This wasn't in the manifesto, this wasn't in the mandate, but because they have a majority, they're able to put it through. A referendum is not a sufficient check on this, because firstly, like, you need 2/3 to strike it down. That's quite a lot to actually strike down, you know, poor legislation. Moreover, because of the self-selection bias of those who vote, right? This depends on every time something goes to the Constitutional Court, then people turning out. There's probably self-selection bias here of older people, whiter people, people who are less liberal. Moreover, the government has the ability to convince people of the necessity of doing something, right? So simply because the population have thought that something is justified, such as the anti-terrorism legislation in the UK, doesn't mean it is justified. Fundamentally also, democracy isn't just about institutions. It's also about a culture of equality and liberty that needed for democracy to make sense. A democracy where 10% of the people are slaves is not a democracy. And constitutional courts are essential in protecting this. Why? Precisely because they judge legislation against fundamental principles. And those fundamental principles may not always be the perfect ones, but they're certainly better than the unrestrained will of the masses towards authoritarianism, towards oppression of majorities. So there's another thing here, right, in that you also need to protect against authoritarianism. In particular, what these courts often do is strike down laws that are not within the remit of the parliament, such as like extending term limits and that kind of thing. That actually, when you put it to a referendum, simply wouldn't be taken as seriously as the constitutional court knows that it should be. It also therefore acts in a way that is incredibly beneficial for the administration by providing subtle checks on the kind of legislation they propose, right? Because if you know that something is likely to be declared unconstitutional, then you're much more likely to actually put forward a different kind of legislation or a more nuanced legislation. This means that fundamentally we think governments work better when they have better checks and balances. This is a legitimate form of that check and balance, incredibly proud to oppose.
So we heard from the previous speaker about the anti-terrorism laws and how government has too much power. The way these laws actually worked was the UK law lords used judicial review and the ECHR in the Belmarsh case to stop it. It did not use strike-down powers, and this is a perfect example of yet again how the government can function and how yet again you can very effectively stop laws if they're deemed unconstitutional without striking them down. Moreover, it was because they didn't have strike-down powers that they were respected. Their authority was respected because they weren't deemed to be politicised. This is yet again another case that falls on our side of the house. My main clash today, who is better placed to defend rights? The rest of my rebuttal will be integrated. So we heard from the proposition that the Constitution is outdated, a lot of these judges are political appointments, and third of all, a lot of these judges are incredibly conservative. They're often from a small range, they're often maybe from one ethnicity, they may not represent lots of different ethnic minorities. No, thank you. And moreover, they're life appointments, and therefore they don't really consider it important whether they are implementing decisions which the public want, whether they are implementing decisions which progress the country, because they are sort of in their sphere of just legalistic, no thank you, academic minds, rather than saying what actually defends rights. The response we heard from the opposition is, well, the fact that they're more independent, the fact that they're life appointments, means they're just going to do the right thing. This is where the difference is. Side opposition thinks the right thing is simply making sure that you get the academic constitutional application. On our side of the house, we say that often the right thing is about defending rights. If the Constitution does not care for the rights of an oppressed group, legalistic academic minds may think that the right thing is continuing to implement that and showing total disregard for that group. But on our side of the house, we think it is far more important that you've got individuals, you've got members of the population, no thank you, who can consider whether that group has the rights that they deserve. That is where the difference is. We heard from Josh that because the old constitution, because of the conservative judges, it's going to be problematic. That was the response, no thank you, we had to opposition's claim that the referendum may not defend the rights of ethnic minorities. When we look at the comparative, Josh showed you that, like, in reality, it is very, very unlikely that you're suddenly going to get a huge proportion of the population ganging up on another small part of the population, especially, no thank you, especially if we go with the opposition's line that we're just talking about developed countries that have already established rights for sort of, no thank you, many people who are otherwise oppressed. No thank you. On the comparative, on the opposition, we are asking people who are educated 50 years ago, who probably haven't had that much interaction with people from very different lifestyles with themselves, as they've led a privileged life their whole way. And third of all, who only care about, no thank you, implementing the letter of the law rather than whether it actually makes people's lives better. We think we win that comparative. We think the population has a broader understanding of the rights of others compared, no thank you, to a privileged lot who are just looking as to whether it's constitutional. So, like, yeah.
If the US Supreme Court had advised the Missouri Board of Education it was unconstitutional to segregate education, do you think the Missouri Board of Education would have accepted that advice?
So, like, I think the reality is, like, first of all, we've heard from Josh how, like, this claim that just because a constitution says it wants to defend the rights of all people, like, demonstrably has not been true. And second of all, moreover, if you want to talk about, like, developed countries, like, if you want to talk about the status quo, if you want to talk about the kind of countries and the kinds of rights that are being preserved at the moment, we don't think it's relevant to talk about something in the past. We think you need to look at, like, what is the US at the moment like? What is the UK at the moment like? We think we need to have that understanding. We don't think you can just say, well, hypothetically, what would that have been a long time ago? Moreover, even if we do go on that line of argument, we think Josh has shown you how there have been vastly more cases where in reality the Constitution has been used to persecute people, to continue oppression. We think that's much more dangerous. We heard from the previous speaker the idea that people may know what they want, but not what is constitutional. And this is where the real difference is. So on their side of the house, they think people simply aren't educated enough because they haven't done 15 PhDs in law. On our side of the house, we think people are much more educated because they know what life is like for people that aren't just privileged. They know what life is like for people who have been oppressed. They know what life is like for people who aren't a select group of law lords. That is much more important. We saw from Josh that the issue is about how best to defend rights. The issue is about how to make the lives of individuals in that country better. The issue is really about when people said that they care about the lives of others, how do we implement that? We heard from Josh how it's going to be much more efficiently implemented, much more effectively implemented, because ultimately you get individuals who can understand what life is like rather than constitutional experts who don't. We think we win that argument. Then we also heard this idea, no thank you, from Josh, that soft review mechanisms are much more efficient. It preserves the legitimacy as they're not meddling. We think when you get caught, they're not telling the government, you have to do this, like you literally have to do this, but instead are telling the population, we strongly advise you to do it. This is why we think it's a beneficial thing. First of all, that removes the problem of the population just being ignorant, as the opposition has claimed, because we think you can get law lords saying, like, this is our understanding of why it's unconstitutional, this is why you should vote this way. Moreover, what it means is when they do advise certain things, they have a huge amount more respect of others. They have more respect of the government, as they're not meddling in their affairs. What this means is they can be much more effective. What this means is when they make decisions, people accept them more easily, because they recognise that it is not a select group of, like, 10 people deciding what life can be like for the rest of the population. Ultimately, what we say is on their side of the house, you have a privileged lot deciding how others should live based on an understanding of an old, outdated and conservative constitution. On our side of the house, we allow the population to decide, with their much better understanding of what life is actually like for the population, how it wants its country to run. We urge you to vote for us.
Okay, in my summation, I'm going to look at 3 areas. First of all, I'm going to deal with the stuff about soft influence that came out of closing proposition, explain why it's not relevant to the debate, and also compare to that to Kate's extension about why legalism is important, judicial precedent is important, and you can't just opt out of specific measures of constitutions. Secondly, though, I'm going to deal with sort of the more general stuff we've heard on the proposition line on why there are problems in Supreme Court, deal with that on a comparative basis, explain how we're clearly winning on our side. Then thirdly, I'm going to speak to you about, again, the stuff that we heard about why we think courts are more pro-majority in general, again, focusing on the stuff that Kate brought to you about expediency and rights and what those actually are. Okay, so firstly, on this sort of on this sort of stuff that we heard about soft power, like, what we hear from closing proposition is the sort of, it's actually really great when courts announce that something is incompatible without having to actually strike down the law, because then the government can be pressured into not doing that. I mean, notice that that didn't actually take place within the model that was set up by a proposition, which is not courts announcing that something is incompatible. It's rather courts saying, this is something we believe to be incompatible, so public, what do you think, right? That's the issue with the case that we heard with the proposition, because we say, like, insofar as soft power courts might work under the moment, or might have any degree of respect, it's on the grounds that people defer to their authority when they come out and say something is incompatible, rather than think of it as an issue for public discussion. We say it's very easy for governments to just resist any power that they might currently have under the status quo, if they can just expect the people to back them, because then it's people plus government versus old judges. You claim that that is a legitimate avenue. That's the thing that we disagree with on side opposition. This was Kate's stuff about why this is important. And particularly the legalism is important. We actually think debates about whether or not you have a right to an abortion in a country should not be about your personal feelings about whether you think something is morally right or morally wrong, but rather, what rights to privacy do you have in a society in which there is a lot of divided opinion about whether or not abortion is right or wrong. So when Tommy stands up in his speech and says, we don't think this discussion should be just legalistic, we think it should actually be about the issues that people have faced, we just fundamentally disagree. These aren't about hot topic buzzing issues in a society, because you might think that abortion is a wrong thing, but you also think that people in your society in general have a right to live free of oppression, and you don't want to be conflating those two issues in a big referendum when the stakes are high and people have lots of personal issues. You've no guarantee on what basis people are voting, and it's probably going to be the wrong one, we say, when you take this as a referendum to the people. In particular, though, this model just in general, right, includes a huge amount of ambiguity to what a constitution even is, right? Because this was Kate's stuff, right, about the AK-47s. It is not clear, right, if there's a law that exists, right, and it gets brought to the court and the court says we think this is unconstitutional, then there's a referendum and people don't get the 2/3 majority needed to take down the law. I mean, does that mean the constitution has changed? Because you haven't agreed on any general principle about what might be different. You haven't agreed on any general principle about what rights might have fundamentally been affected. You just say that we're happy with this law. That's the issue with not having a legalistic basis to these discussions. That's an issue about just being able to randomly opt out of more general human rights. What do we see as the role of constitutional courts, ladies and gentlemen? We say that you sign up to them because you recognise that they guarantee certain fundamental protections, right? The right to privacy, the right to equality, the right to individual dignity. And the point is that means you might not agree with every individual decision that the Constitutional Court makes on any individual topic, but you think there is a broader framework here, and that in general you support that broader framework, and that would get undermined if you just pick and choose, which minorities you're happy to have these rights and which minorities you think they aren't. It undermines the more general principle which we think people do agree to, do consent to, and that cannot function under your system. I'll take closing.
All it does, between on the edit, is courts decide more. Okay? When courts can decide against public opinion, as they do in America at the moment, see Hobby Lobby, what happens to the Supreme Court then?
We think it's perfectly courts acted this way. Notice, though, that courts do have to publish justifications for their decisions, and their justification is very commonly, for example, Lawrence v. Texas, when they struck down sodomy stores in the U8, you might not agree with homosexuality, but there's a guaranteed right to privacy within the US Constitution, which means that what goes on between consenting adults and that does not pose significant harm to society is, quite frankly, none of your business and none of the business of the law. Maybe not everyone's convinced by that in these cases, but we think fundamentally the more important thing is that gay people stop going to prison for having sex. Okay. Second area of clash, though, about the problems, right? So ultimately, like, what were the problems? Like, we heard this idea that, like, some constitutions are one thing I really want to make very clear, like, the model is that you need a 2/3 majority, right, in order to get the oppressive law gone, right? So it's not even like you need 2/3. No. We asked for a clarification. That's what it was. 2/3 need to be get to strike the law down, right? So that means in their cases that they want to talk about, like Sri Lanka, right, you would have to have a liberal government pushing through a pro-Tamil law, which the Supreme Court, which is entirely anti-Tamil, says is unconstitutional, and then 2/3 of the Sri Lankan people would have to side with the Tamils, rise against the Constitutional Court in order for this policy to work in any type of the way that you think it would. And so, like, that is just not fundamentally the balances that we would see in society in terms of majoritarianism. We say in general that if a population is anti-minority, then the parliament tends to be anti-minority too, and they all work together, and the courts are the independent check on that. I think the most important stuff was about political interference in this point, right? And the idea that they're just politically appointed, but you can't get them to leave. But we say, look, there are internal pressures in these circumstances. Like, in particular, right, if you're like, they said they could just do it on any basis, not even a legalistic one. First of all, recognize that these people who have a huge amount of prestige and legal experience, and they're not people who take their jobs lightly in general. But secondly, if you are just being political, if you are just striking down decisions just for the sake of it, then you're not completely immune from pressure, right? So in the 1930s, when the Supreme Court in America was striking down FDR's like New Deal legislation, then there was a threat, right, by the government to massively expand the pool of judges on the court. And that caused them to stop striking down this legislation. Like, this doesn't mean they're not independent, but it does mean that if they're acting in like ridiculously political ways that have no legal basis, then in that very rare case you can get government intervention, and that acts as enough of a deterrent to stop that happening in any significant case. Finally, though, why they're pro-minority in general, because what we said, right, in closing opposition, is that when you look at fundamental rights, then those are things that you can draw on and apply in more of a case, right? This is why, like, even like Scalia, who's like super conservative, voted to take down Proposition 8 because he thought there was a fundamental imposition on the democratic rights of people to be governed through like jurisdictions. Thought a referendum was an unfair way to go about that. But furthermore, stuff like the right to privacy, the right to equality, and safeguards against expediency in particular, treating people as ends and not means and not ends, and populism is what really makes these courts in general vaguely pro-minority. Even if they don't get anything right on the comparative, they're better. We beg to oppose.